Has this been a couple of wonderful days or what? We are honored, we are humbled by the presence of so many friends and supporters. To begin with, I have an exciting announcement. I want to announce that Judge Nathaniel Jones and Attorney General Janet Reno has each agreed to join ACS's National Board of Advisors. Thank you. Judge Jones is recently retired from the United States Court of Appeals for the Sixth Circuit, to which he was appointed by President Carter in 1979, after having served for a decade as General Counsel of the NAACP. Janet Reno, of course, was the 78th Attorney General of the United States. She was the first woman ever appointed to that office, and the longest-serving Attorney General in the 20th century. She will be speaking tomorrow morning and, of course, hosting Janet Reno's dance party later tonight. We are deeply honored that Judge Jones and General Reno have joined us as advisors. You are part of an historic event. Who would have thought, from a campus group with a single chapter just 2 years ago, we would grow to this? This has been an extraordinary experience for me and for all of us at ACS, and it's all because of you. The goal of ACS, as you well know, is to restore the values of respect for human dignity, protection of individual rights and liberties, genuine equality, and access to justice to their rightful and traditionally central place in American law. The extraordinary programming we have seen at this convention has, I hope, begun to point the way. It has been both inspirational and educational. This kind of programming shows how ACS, nationally, but also on your campuses and in your communities, can begin to frame and propagate ideas that will strengthen a more humane and progressive law and politics in the United States. And this incredible turnout shows that there is a thirst for just this kind of programming. Words cannot express the debt of gratitude we owe to our unbelievable speakers and panelists. They have been nothing short of incredible. Please, please join me in thanking them collectively. For their participation, involvement, and support of ACS. I have, of course, been thanked a lot. And no. and publicly. And I am humbled, too, by your gratitude. But the thanks for this magnificent event really belong to those whose very hard work over the past 7 months have made this convention a reality. Lisa Brown, our executive director, has done a magnificent job leading ACS. It is a pleasure and an honor to work with her, and I want to thank her. Melody Barnes, of whose talents you glimpsed only a tiny slice during yesterday afternoon's program, along with Lisa, has been ultimately responsible for everything that has happened here. Hasn't she done an extraordinary job? ACS is so lucky to have them both. The convention program itself was planned over the past 7 months by our convention planning committee. Those who served on it included Lisa, Melody, and me, as well as our outstanding Deputy Director, David Lyle, who gave out the chapter awards this afternoon, without whose steady hand this convention would not have been so successful, and who we should also thank. Bill Marshall, professor of law at UNC, faculty advisor of our chapter there, and indispensable part of ACS, who spent countless hours on conference calls over many months, helping to guide, shape, and create the program, and who also could not receive enough recognition. And, of course, our former executive director, David Halpern. We owe David an enormous debt of gratitude. His work was invaluable not only to the planning of the convention, but to ACS's extraordinary growth and success. The convention has depended on the generous financial support of its sponsors, who are acknowledged by name in the convention book. Without law firms and organizations willing to put their money where their beliefs are, this convention would not have been possible. So when you're thinking of where you might like to work, law students, remember those whose generosity have made this possible. The convention also could not have been a success without the support of two of ACS's dearest friends, Judy Lichtman and Walter Dellinger. We also owe thanks to our board of advisors, Brooksley Bourne, Governor Mario Cuomo, Drew Days, Walter Dellinger, Maria Echaveste, Chris Edley, Eric Holder, Judge Shirley Hufstedler, Senator Charles Mathias, Frank Michelman, Judge Abner Mikva, Judge William Norris, Deval Patrick, Larry Tribe, and Judge Patricia Wald, and to my fellow directors who have worked so hard to make what was once just an idea being discussed in an ill-lit conference room into a reality. Sorry, Lori, it was an ill-lit conference room. Their wisdom, counsel, and hard work have been invaluable to ACS. They are ACS Vice President Teresa Wynn Roseborough, Bob Brownice, Scott Gale, Pam Harris, Jeff Kleinberg, Rob Malley, and Lori Rubiner. But as you can imagine, and as you have seen over the past 2 days, amazing in their spirit, their organization, and their dedication are the staff of the ACS National Office. Lisa Brown and David Lyle I've mentioned, also David Sewell, Kimberly Sneed, Rachel Whitlark, and especially Allison Gold, whose long hours of uncomplaining work are responsible for so much of what you see here. We also owe a special thanks to our consultant, Alicia Alexion, to our law clerks and fellows, Kate Riggs, Michael Bukai, Mawia Hooker, Veronica Nelson, and Danielle Goldstein, and to the many volunteers whose efforts have ensured that the convention has run smoothly. Finally, yes, and let's have a round of applause for them. Finally, we owe our deepest thanks to you. You are the American Constitution Society. This is your organization, and we want to make it possible for you to be as involved as you want to be. We want you to launch or be involved with the chapter on your campus. Materials on how to start a law school chapter are available on the web. If you're a practicing lawyer, we want to help you to launch a successful chapter in your community. And early in the fall, we will have materials available on the web to assist you in doing so. Our national office is here to assist you with programming, advice, and even financial support. We hope that this convention has been a first step in introducing you to like-minded students, faculty members, practitioners, and others. We hope our programming has helped begin the work of showing that American law has its roots in and can return to be replenished at the fountain of the values we share. And we hope that you will take the remarkable energy of this weekend back to your campuses and communities around the country. The goal of the American Constitution Society is to help law students and lawyers understand the legitimacy and vitality of a vision of the law in which compassion and human dignity, individual rights and equality have a central place, and to demonstrate to them that rigorous legal thinking does not require abandoning one's values. The work and life of our keynote speaker are living proof of these truths. After graduating from Columbia Law School, Ruth Bader Ginsburg was instrumental in launching the Women's Rights Project of the ACLU. Throughout the 1970s, she litigated landmark cases before the Supreme Court that culminated in recognition of the principle that the Constitution prohibits invidious sex-based discrimination. You know the names of the cases she argued: Frontiero v. Richardson, Weinberger v. Wiesenfeld, Califano v. Goldfarb. She was a professor of constitutional law, first at Rutgers and then for 9 years at Columbia Law School, before President Carter appointed her in 1979 to the United States Court of Appeals for the D.C. Circuit. In 1993, President Clinton elevated her to the Supreme Court. The 10th anniversary of her taking her seat is just 8 days from now. On the Supreme Court, Justice Ginsburg has continued, through both her voice and her vote, to be a champion of equality and liberty. She is the author of the landmark opinion for the court in United States versus Virginia, the BMI case in 1996, and has pronounced perhaps the court's strongest views about equality as recently as her separate opinion in Gratz less than 2 months ago, where she wrote that, and I quote, "The stain of generations of racial oppression is still visible in our society, and the determination to hasten its removal remains vital." She was in the 5-4 majority in Stenberg that upheld a woman's right to choose, and joined the 5-member majority opinion in Lawrence versus Texas, striking down Texas's same-sex sodomy law. She routinely dissents from the so-called new federalism decisions, restricting Congress's Commerce and Section 5 powers, and protecting the states under novel interpretations of the 10th and 11th Amendments. And of course, in 2000, she would have permitted the presidency to be determined by the counting of the ballots cast by America's voters. Justice Ginsburg's work has literally changed the face of America. Ruth Bader Ginsburg's life is testimony to the fact that ideas matter and that law can make a difference. We are deeply grateful that she has chosen to honor ACS by giving the keynote address at our first national convention. A national hero and a great and dear friend of the American Constitution Society, Ruth Bader Ginsburg.
Sit down. In the good job I have had now for some 10 years, I try to follow Justice Brandeis's counsel. Resist even the irresistible invitation, he said. Conserve time for the court's heavy work. But when Caroline Brown and Peter Rubin asked me to speak at this first national gathering of the American Constitution Society, I just said yes, because the Society's mission is important to the health and welfare of our nation. The jurists and students assembled here seek to advance the highest ideals of the Union our fundamental instrument of government establishes. You cherish liberty and would make equal opportunity and non-discrimination genuinely this country's law and practice. And you will pursue justice so that you may thrive. While you are the American Constitution Society, your perspective on constitutional law should encompass the world. The United States was once virtually alone in exposing laws and official acts to judicial review for constitutionality. But particularly in the years following World War II, many nations installed constitutional review by courts as one safeguard against oppressive government and stirred up majorities. National, multinational, and international human rights charters and tribunals today play a key part in a world with increasingly porous borders. My message tonight is simply this: we are the losers if we do not both share our experience with and learn from others. The message is hardly original. A prominent jurist put it this way 14 years ago. For nearly a century and a half, courts in the United States, exercising the power of judicial review for constitutionality, had no precedents to look to save their own, because our courts alone exercise this sort of authority. When many new constitutional courts were created after the Second World War, these courts naturally looked to the decisions of the Supreme Court of the United States, among other sources, for developing their own law. But now that constitutional law is solidly grounded in so many countries, it is time that the United States courts begin looking to decisions of other constitutional courts to aid in their own deliberative process. The speaker was Chief Justice William H. Rehnquist. More recently, Justice O'Connor said, while ultimately we must bear responsibility for interpreting our own laws, there is much to learn from distinguished jurists in other places who have given thought to the same difficult issues that we face here. In the value I place on comparative dialogue, on sharing with and learning from others, I count myself an originalist in this sense. The 1776 Declaration of Independence, you will recall, expressed concern about the opinions of other peoples. It placed before the world the reasons why the United States of America, the new nation was called that in the Declaration, was impelled to separate from Great Britain. The Declaration did so out of a decent respect to the opinions of mankind. It submitted the facts, the long train of the British Crown's abuses, to the scrutiny of a candid world. In writing the Constitution, the framers looked to other systems and to thinkers from other lands for enlightenment, and they understood that the new nation would be bound by the law of nations, today called international law. Among powers granted Congress, the framers enumerated the power to define and punish offenses against the law of nations. John Jay, one of the authors of the Federalist Papers and our first Chief Justice, wrote in 1793 that the United States, by taking a place among the nations of the earth, had become amenable to the law of nations. 11 years later, Chief Justice John Marshall cautioned that an act of Congress ought never to be construed to violate the law of nations if any other possible construction remains. And in 1900, the court famously reaffirmed in the Paqueta Habana that international law is part of our law and must be ascertained and administered by the courts of justice. For this purpose, where there is no treaty and no controlling executive or legislative act or judicial decision, resort must be had to the customs and usages of civilized nations. To discern the rule of law among nations, the court said in the Paqueta Habana, judges were to look to the works of jurists and commentators who by years of labor, research, and experience have made themselves peculiarly well acquainted with the subjects of which they treat. Today, tools are readily at hand to pursue international and comparative law inquiries. The Internet affords access to foreign judicial decisions. Law journals contain all manner of commentary. Course materials are well packaged. In 1999 and 2003, leading U.S. law book publishers produced 2 excellent sets of cases and materials on comparative constitutional law. These works should attract teachers and students to the field. My colleague, Justice Stephen Breyer, speaks enthusiastically of his hopes for the wired world. Audio and visual technology in new classrooms, he notes, already permit U.S., Canadian, European, or Indian professors to team teach classes held simultaneously in different nations. Technological developments, he predicts, will inevitably open vistas in courtrooms as well as classrooms. True, there is a discordant view on recourse to the opinions of mankind. A mid-19th century Chief Justice expressed that view concisely. No one, we presume, supposes that any change in public opinion or feeling in the civilized nations of Europe or in this country should induce the court to give the words of the Constitution a more liberal construction than they were intended to bear when the instrument was framed and adopted. Those words were penned in 1857. They appear in Chief Justice Roger Taney's opinion for a divided court in Dred Scott v. Sanford, an opinion that invoked the majestic due process clause to uphold one individual's right to hold another in bondage. Jurists identified as today's originalists adhere to the view that a comparative perspective, though useful in the framing of our Constitution, is inappropriate in its interpretation. Partisans of that view sometimes carry the day in our courts. I anticipate, however, that they will speak increasingly in dissent. 2 cases in point. In 1989, in Stanford v. Kentucky, the court held it was not cruel and unusual punishment under the Eighth Amendment to sentence an individual to death for a crime committed at age 16 or 17. Rejecting the relevance of the sentencing practices of other countries, the court emphasized that it is American conceptions of decency that are dispositive. 13 years later, in Atkins v. Virginia, the court held that executions of mentally retarded criminals are cruel and unusual punishment prohibited by the Eighth Amendment. The 6-member majority noted that within the world community, the imposition of the death penalty for crimes committed by mentally retarded offenders is overwhelmingly disapproved. In a 1996 address at American University, Chief Justice Rehnquist said, "The framers of the United States Constitution came up with 2 original ideas. The first was a chief executive who was not responsible to the legislature, as a chief executive is under the parliamentary system. The separation of legislative and executive authority established under Articles 1 and 2 of the U.S. Constitution," the Chief Justice noted, "has not been embraced by many other nations. But the second idea, an independent judiciary with the authority to declare laws passed by Congress unconstitutional, has caught on abroad, particularly since the end of the Second World War. Of that idea," the Chief Justice said, constitutional review by independent tribunals of justice is one of the crown jewels of our system of government today. I agree, but the just pride we take in our system of constitutional review, also in our judicially enforceable Bill of Rights, hardly means we should rest content with our current jurisprudence and have little to learn from others. May I suggest two areas in which, as I see it, we could do better. One concerns the dynamism with which we interpret our Constitution and similarly our common law. The other involves the extraterritorial application of fundamental rights. Chief Justice Tawney, in the passage I earlier quoted, described a constitutional text frozen in time. Contrast the view stated in Trope v. Dulles, a path-marking 1958 plurality opinion, at issue in that case, the proper reading of the Eighth Amendment's ban on cruel and unusual punishments. Those words, the opinion said, must draw their meaning from the evolving standards of decency that mark the progress of a maturing society. As the 2002 decision banning executions of the mentally retarded, Atkins v. Virginia, expressly reaffirmed, a majority of the U.S. Supreme Court justices generally adhere to that understanding, but the frozen-in-time position occasionally holds sway. A recent example, one that involves no grand constitutional question, simply equity between parties with no ideological score to settle. A Mexican company defaulted on payments due a U.S. creditor and was sued in a federal district court, which had personal jurisdiction over the debtor. Sliding into insolvency, the Mexican company was busily distributing what remained of its assets to its Mexican creditors. It did so in clear violation of a contractual promise to treat the U.S. creditor on a par with all other unsecured creditors. If that activity continued, nothing would be left in the till for the U.S. creditor. Since 1975, English courts had been providing a remedy in similar circumstances. To assure that there would be assets against which a final judgment for the creditor could be executed, they would order a temporary injunction restraining the foreign debtor from transferring assets pending adjudication of the creditor's claim. The U.S. District Court, ruling over 2 decades later, looked to the English practice, which other common law nations had by then adopted, and found it altogether fitting for the U.S. creditor's case against the Mexican debtor. At the hearing on the preliminary injunction, the district judge asked, "We have got a case here where no plausible defense is presented. Why shouldn't I be able to provide the creditor with injunctive relief? Why should the debtor be allowed to use the process of the court to delay entry of a judgment as to which there is no defense? Why is that equitable?" Overturning a Second Circuit decision that affirmed the preliminary asset freeze order, a 5-4 majority of the Supreme Court in 1999 answered the district judge's questions this way. Injunctions of the kind at issue, called Moreva injunctions, the short name of the 1975 English case that first approved the practice, were not traditionally accorded by courts of equity at the time the Constitution was adopted. Any substantial expansion of 1789 practice, the court said, was the prerogative of Congress, a power that English courts did not actually exercise until 1975. The court concluded was not one that U.S. courts could assume. Joined by Justices Stevens, Souter, and Breyer, I dissented from the court's static conception of equitable remedial authority. Earlier decisions described that authority as supple, adaptable to changing conditions. I noted, among other things, that federal courts, in their sometimes heroic efforts to implement the public school desegregation mandated by Brown v. Board of Education, did not embrace a frozen-in-time view of their equitable authority, issuing decrees beyond the contemplation of the 18th century chancellor. They applied the enduring principles of equity to the changing needs of a society still in the process of achieving a more perfect union. Turning from frozen-in-time interpretation to another shortfall, the Bill of Rights, few would disagree, is our nation's hallmark and pride. One might assume, therefore, that it guides and controls U.S. officialdom wherever in the world they carry our flag or their credentials. But that is not our current jurisprudence. For example, absent an express ban by treaty, a U.S. officer may abduct a foreigner and forcibly transport him to the United States to stand trial here. The court so held 6-3 in 1992. Just a year earlier, South Africa's highest court had ruled the other way, determining that abduction violates the applicable rules of international law. Another example, one that involves civil litigation. Interpreting Supreme Court precedent, the D.C. Circuit held in 1989, during my time on that court and over my dissent, that foreign plaintiffs acting abroad, the plaintiffs were Indian family planning organizations, had no First Amendment rights and therefore no standing to assert a violation of such rights by U.S. officials. In dissent, I resisted the notion that in an encounter between the United States and non-resident aliens, the amendment we prize as first has no force in court. I expressed the expectation that the position taken in the Restatement Third of Foreign Relations would one day accurately describe our law. Wherever the United States acts, the restatement projects, it can only act in accordance with the limitations imposed by the Constitution. With human rights increasingly prominent on the world's agenda, that day may come sooner rather than later. The idea was well stated by a distinguished Columbia Law School professor, my dear colleague Louis Henkin, when he wrote, "In a world of states, the United States is not in a position to secure the rights of all individuals everywhere, but it is always in a position to respect them. Our federal government must not invade individual rights of any human being. The choice in the Bill of Rights of the word person rather than citizen was not fortuitous, nor was the absence of a geographical limitation. Both reflect a commitment to respect the individual rights of all human beings." In celebration of the Supreme Court of Canada's 125th anniversary 3 years ago, I remarked on the impressive human rights decisions that court had made since the 1982 adoption of Canada's Charter of Rights and Freedoms. Interpreting the Charter, Canada's Supreme Court, as of 1996, had referred in some 50 cases to international human rights instruments. In contrast, since the United Nations 1948 adoption of the Universal Declaration of Human Rights, the U.S. Supreme Court has mentioned that most basic international declaration a spare 6 times and only twice in a majority decision. But our island or Lone Ranger mentality is beginning to change. Our justices, as I noted at the start of these remarks, are becoming more open to comparative and international law perspectives. The term just ended may prove a milestone in that regard. New York Times reporter Linda Greenhouse observed in her annual roundup of the court's decisions, "The court has displayed a steadily growing attentiveness to legal developments in the rest of the world and to the court's role in keeping the United States in step with them. In the Michigan affirmative action cases, in separate opinions, joined in one case by Justice Breyer, in the other in full by Justice Souter, and in part by Justice Breyer, I looked to two United Nations conventions, the 1965 International Convention on the Elimination of All Forms of Racial Discrimination, which the United States has ratified, and the 1979 Convention on the Elimination of All Forms of Discrimination Against Women, which, sadly, the United States has not yet ratified. Both conventions distinguish between impermissible policies of oppression or exclusion and permissible policies of inclusion, temporary special measures aimed at accelerating de facto equality. The Court's decision in the law school case, I observed, accords with the international understanding of the Office of Affirmative Action. A better indicator, because it attracted a majority, is Justice Kennedy's opinion, is his opinion for the Court in Lawrence v. Texas, announced June 26. Overruling the Court's 1986 decision in Bowers against Hardwick, Lawrence declared unconstitutional a Texas statute prohibiting two adult persons of the same sex from engaging voluntarily in certain intimate sexual conduct. On the question of dynamic versus static interpretation, the Court's opinion instructs, had those who drew and ratified the due process clauses of the Fifth and 14th Amendments known the components of liberty in its manifold possibilities, they might have been more specific. They did not presume to have this insight. They knew time can blind us to certain truths, and later generations can see that laws once thought necessary and proper, in fact, serve only to oppress. As the Constitution endures, persons in every generation can invoke its principles in their own search for greater freedom. And on respect for the opinions of humankind, the Court emphasized the right the petitioners seek in this case has been accepted as an integral part of human freedom in many other countries. In support, the Court cited the leading 1981 European Court of Human Rights decision, Duggan against United Kingdom, and follow-on European Human Rights Court decisions affirming the protected right of homosexual adults to engage in intimate consensual conduct. Recognizing that forecasts are risky, I nonetheless believe we will continue to accord a decent respect to the opinions of humankind as a matter of comedy and in a spirit of humility. Comedy because projects vital to our well-being, combating international terrorism is a prime example, require trust and cooperation among nations the world over. And humility because, in Justice O'Connor's words, other legal systems continue to innovate, to experiment, and to find new solutions to the new legal problems that arise each day, from which we can learn and benefit. In conclusion, my cheers as you undertake the challenging mission to support and nurture the Constitution as it has evolved over the span of 2 centuries and more. The time is right for that mission. As Abigail Adams wrote to her son of the era in which he was coming of age, these are the times in which a genius would wish to live. It is not in the still calm of life or the repose of a Pacific station that great characters are formed. The habits of a vigorous mind are formed in contending with difficulties. I thank you for your great patience.